Tonight, our next speaker will be giving us some insight into Justice Scalia's legacy and some of his more interesting Supreme Court opinions. Please welcome up our president, Erik Wiese, with the speech titled Antonin Scalia in 12 minutes.
All right.
8 to 12.
10 to 12. 10 to 12.
And this is a manual speech also, which I just decided on in the last 10 seconds.
You got a manual speech?
I did. I brought it with me.
This is Bob Helix.
So Mr. Scalia's son, who happens to be a Methodist preacher, was giving his dad's eulogy. And he said one of the funniest things that he remembered about his dad was how he would take confessions. And there was multiple ministers that were in their church. And he looked up and saw that his dad, not realizing that he was in his son's line, then figured it out and quickly ran off into a different line to do his confession. And when confronted with this later, Mr. Scalia said, "I'll be damned if I'm going to confess to you." I thought it was funny.
Methodist?
Yes.
Okay, we'll talk later. Because I was a Methodist and I don't remember.
Hey, whose speech is this?
Anyone who wants to contribute, feel free to just jump on in.
Well, that leaves up.
So we got to listen to President Obama talk about how he wanted to eulogize Mr. Scalia, but we didn't hear anything about what Mr. Scalia had actually said when he was on the bench. And I think a true eulogy of this man would actually entail reading some of his words. It was his words that he used to the greatest effect when he was on the bench. It was his words that are his legacy. And some of these words are fairly interesting. So I'm going to read to you a series of some of the words he used in some of his decisions. For example, this case involving legal requirements for the content and labeling of meat products, such as frankfurters, affords us a rare opportunity to explore simultaneously both parts of Bismarck's aphorism that no man should see how laws or sausages are made. In law school, I never understood antitrust law. I later found out in reading the writings of those who now do understand it that I should not have understood it because it did not make any sense then either. In regards to legislating from the bench, Morrison versus Olson, evidently the governing standard is to be what might be called the unfettered wisdom of a majority of this court, revealed to an obedient people on a case-by-case basis. He didn't like the independence counsel law. And in response to that he said, "How frightening it must be to have your own independent counsel and staff appointed, with nothing else to do but investigate you until the investigation is no longer worthwhile." Interesting enough, both the Republicans and the Democrats decided not to renew the independent counsel law after their respective presidents got savaged by it. On affirmative action, those who believe that racial preferences can help to even the score display and reinforce a manner of thinking about race that was the source of the injustice and that will, if it endures within our society, be the source of more injustice still. It was against affirmative action. In regards to abortion, he didn't think it was something that the courts should be involved with. He thought the state legislatures should be the one involved. And so his comment was, "We can now look forward as a result of yet again entertaining this question to at least another term with carts full of mail from the public and streets full of demonstrators urging us, their unelected and life-tenured judges who have been awarded those extraordinarily undemocratic characteristics precisely in order that we might follow the law despite the popular will, to follow the popular will." He didn't believe that the judges should be following the popular will or interpreting the desired parades. He thought they should be looking at the law. In regards to abortion, there was a lot of controversial cases, so I'm going to have to touch on a lot of things that some of you might not be comfortable with. The Constitution contains no right to abortion. It is not to be found in the long-standing traditions of our society, nor can it be logically deduced from the text of the Constitution. Not, that is, without volunteering a judicial answer to the question of when human life begins. Leaving this matter to the political process is not only legally correct, it is pragmatically so. That alone, and not lawyerly dissection of federal judicial precedents, can produce compromises satisfying a sufficient mass of the electorate, that this deeply felt issue will cease distorting the remainder of our democratic process. The court should end its destructive intrusion into this field as soon as possible. And now you know why he wrote all of this stuff down, because when I read it, it's sometimes indecipherable. You have to be a real genius to understand what these Supreme Court justices are saying. Here's another one. Perhaps the dissenters believe that offense to others ought to be the only reason for restricting nudity in public places generally. I had to put something in here to wake you guys up. The purpose of Indiana's nudity law would be violated, I think, if 60,000 fully consenting adults crowded into the Hoosier Dome to display their genitals to one another, even if there was not an offended innocent in the crowd. See, now we're getting more exciting. On the Pledge of Allegiance, which he thought should have been upheld. In Barnett, we held that a public school student could not be compelled to recite the pledge. We did not even hint that she could not be compelled to observe respectful silence. Logically, that ought to be the next target of this court's bulldozer. He dissented in that opinion. Individuals who have been wronged by unlawful racial discrimination should be made whole, but under our Constitution there can be no such thing as either a creditor or a debtor race. That concept is alien to the Constitution's focus upon the individual. To pursue the concept of racial entitlement, even for the most admirable and benign of purposes, is to reinforce and preserve for future mischief the way of thinking that produced race slavery, race privilege, and race hatred. In the eyes of government, we are just one race here. It is American. This is a comment upon the entire judicial process in the National Endowment versus the Arts versus Finley. The operation was a success, but the patient died. What such a procedure is to medicine, the court's opinion in this case is the law. In Dickerson versus United States, he dissented. What today's decision will stand for, whether the justices can bring themselves to say it or not, is the power of the Supreme Court to write a prophylactic, extra-constitutional constitution binding on Congress and the states. This is why he was considered to be very witty, and he had a lot of dissents that people are writing and looking at. It seems to me that the more Christian a country is, the less likely it is to regard the death penalty as immoral. Abolition has taken its firmest hold in post-Christian Europe and has support in the church-going United States, the least amount of support in the church-going United States. I attribute that to the fact that for the believing Christian, death is no big deal. Intentionally killing an innocent person is a big deal. It is a grave sin which causes one to lose his soul. But losing this life in exchange for the next? The Christian attitude is reflected in the words Robert Bolt's play has Thomas More saying to the headsman, "Friend, be not afraid of your office. You send me to God." For the non-believer, on the other hand, to deprive a man of his life is to end his existence. The Texas anti-sodomy statute undoubtedly imposes constraints on liberty. So do laws prohibiting prostitution, recreational use of heroin, and for that matter, working more than 60 hours per week in a bakery. But there is no right to liberty under the Due Process Clause, though today's opinion repeatedly makes that claim. The 14th Amendment expressly allows states to deprive their citizens of liberty so long as due process of law is provided. That was on the dissenting in the Lawrence v. Texas. Here's an interesting comment. If you're going to be a good and faithful judge, you have to resign yourself to the fact that you're not always going to like the conclusions you reach. If you like them all the time, you're probably doing something wrong. Do any of you guys have some of these Supreme Court decisions you don't like? I have, unfortunately, too many of them.
Obamacare subsidies from the feds to the states, where they decided that the law didn't mean what was clearly written.
Yep. All right. don't invent new minorities. In August 2013, Scalia charged that the High Court was making congressional decisions such as inventing new classes of minorities. Referencing the Supreme Court's decision on gay marriage and benefits for same-sex couples, Scalia said the court's job isn't to create exceptions outside of the Constitution. It's not up to the courts to invent new minorities that get special protections, he said. You know, another thing that he said in that case that my wife and I have discussed is he came out and said that now that homosexual marriage has been approved, it's not too much to expect that you will be allowed to have marriages with more than one person, and that perhaps the Muslims and the Mormons might collaborate in trying to have multiple consecutive marriages. So I approached my wife and said, you know, honey, there might be a silver lining in this whole thing for us. I might end up being legally allowed to have a couple extra women running around the house doing errands for me and special favors. And she said, well, what works for you will work for me. I might be able to have some men who actually go to work and make money instead of writing Toastmaster speeches.
I'm liking this woman.
Well, that concludes my dissertation on this fabulous hero who died to try and teach us something while he was alive. So let's listen.